This is Barry Zalma speaking for Claim School Incorporated, the Zalma on Insurance blog. Today we're going to talk about why an evil employee still allowed his employer to be defended by their commercial insurance policy. And we'll explain why, when an insurer refuses to defend an insured, the fees incurred by the insured are presumed to be reasonable and necessary, regardless of what an insurer might believe to be reasonable and necessary, and why an insurer should seriously consider defense under a reservation of rights rather than refuse defense unless it's absolutely certain there is no coverage. In this case, coverage was found by the Seventh Circuit Court of Appeal, and then the argument resulted on how much. It all started because of Larry Nassar, who was affiliated with nonprofit USA Gymnastics, Inc., USAG, by sexually assaulting hundreds of female athletes. After Nassar's conduct came to light, USAG faced many lawsuits and multiple investigations. USAG and its insurers, including Liberty Insurance Underwriters, Inc., litigated questions about insurance coverage in an adversary proceeding before a bankruptcy court. In a previous appeal, among other rulings, the Seventh Circuit affirmed the decision that Liberty had a duty to defend USAG. In USA Gymnastics versus Liberty Insurance Underwriters, an August 16, 2022 decision of the Seventh Circuit Court of Appeal, Liberty disputed the amount of fees of which USAG was entitled after liability of Liberty to defend was established by the Seventh Circuit. There were also ancillary disputes over the amount of attorney's fees that Liberty owed to USAG. The underlying facts were described in USAG versus Liberty Insurance Underwriters, a Seventh Circuit decision at 27 F. 4th 499. In short, Nassar used his position with the USAG to sexually assault hundreds of women and girls over several decades. Because of that abuse, USAG has faced hundreds of lawsuits by former athletes, as well as several investigations by federal and state entities, including Congress, the Indiana Attorney General, and the United States Olympic and Paralympic Committee. Faced with cross motions for summary judgment, the bankruptcy court concluded that Liberty's policy covered the athlete lawsuits and various investigations. Liberty filed objections to the bankruptcy court's findings and conclusions, but the district court overruled these objections. In January of 2020, the district court ordered Liberty to provide a complete defense to USAG with respect to several matters, including the athlete lawsuits and several investigations. The district court also ordered Liberty to reimburse USAG for its defense costs, but the court did not award damages in any specific amount. Liberty appealed the district court's order. While the first appeal was pending, the parties continued to dispute and litigate issues concerning payment. Liberty did not agree to USAG's demand and sought to stay the district court's defense order. In turn, USAG moved to enforce the order. In addition, USAG offered the expert testimony of attorney Gene Schoon, who had prior experience serving as a national coordinating counsel during his days as a practicing lawyer. He testified that in his opinion, all the fees USAG sought were reasonable and necessary. On the other hand, Liberty presented the expert testimony of attorney Brad Brand Cooper. At that point, Cooper testified that he determined certain fee amounts incurred by USAG, which totaled about $1.43 million, were reasonable and necessary. Yet, almost immediately, on redirect, Cooper contradicted his prior testimony. In answer to the court's question, Cooper expanded on the nature of his objections but refused to give concrete figures that were not disputed. In September of 2020, the bankruptcy court entered proposed findings and conclusions. The court rejected Liberty's arguments and concluded that under applicable case law, USAG was entitled to a presumption that the fees incurred were reasonable and necessary. The court also found Schoon to be more credible and a reliable expert witness. Accordingly, the bankruptcy court concluded that USAG had proved by a preponderance of the evidence that $1,944,354.26 of the fees it incurred were reasonable and necessary. So the court recommended the district court enter judgment in that amount, plus prejudgment interest. Liberty filed objections to the bankruptcy court's proposed findings and conclusions, and with some prepayments, the live controversy because of payments made by Liberty before the Seventh Circuit concerned the remaining $458,472.26 of the judgment. Liberty contended that bankruptcy and district courts had properly applied the law when they concluded that the fees USAG incurred were reasonable and necessary. The Seventh Circuit noted that in Taco Bell Corp. Versus Continental Casualty Company, the Seventh Circuit considered a scenario in which an insurer had breached its duty to defend but later argued the policyholder had incurred excessive fees. Under these circumstances, the court held, the policyholder had an incentive to minimize its legal expenses, such that there was no occasion for a painstaking judicial review. The presumption is akin to a burden of proof because it determines the outcome in cases where the evidence is in equipoise and therefore advances the substantive policies of the state. This points to the presumption as more substantive than procedural. In Liberty's view, USAG is not entitled to the presumption because it failed to adequately supervise the outside counsel it engaged, and it did not pay in full the fees it incurred. According to Liberty, USAG did not meaningfully supervise outside counsel because Schneider, the head person at USAG, never requested write-offs from outside counsel and rarely followed up with them to ask questions about the invoices they submitted. Now, a litigant may supervise its outside counsel without refusing to pay a portion of legal bills or engaging in hair-splitting about those bills. Nothing in the case provides otherwise. Liberty argues that the Thompson presumption that the fees were reasonable and necessary does not apply because USAG failed to pay about 30% of the fees it incurred. The market-tested presumption applies, however, when following an insurer's breach of the duty to defend. A policyholder has supervised and incurred legal fees without any expectation of payment by the insurer. Payment by the policyholder is not necessarily required. This is because, as here, the policyholder may lack sufficient funds to pay fees that are reasonable and necessary to its defense. But if the policyholder does not pay a significant percentage of its fees, particularly when it has difficulty covering its day-to-day operating expenses, that is strong evidence of market incentives to economize, rendering the presumption applicable. It was undisputed that USAG paid nearly 70% of the attorney's fees for which it now seeks reimbursement. That is compelling evidence of a market test. This element of the Thompson presumption supports rather than contradicts the bankruptcy and district court's conclusion that the fees USAG claimed are presumed to be reasonable and necessary. An insurer's objection to a policyholder's selection of defense counsel lose force when the insurer disclaims its duty to defend and turns out to be wrong on the law. Had Liberty mistrusted USAG's incentive to economize on its legal costs, Liberty could have reserved its defense that it had no duty to defend and assumed USAG's defense. In that scenario, Liberty could have selected and supervised and paid for the lawyers defending USAG, and Liberty could later have sought reimbursement if it proved that it had indeed had no legal duty to defend. Liberty chose not to do so, instead electing to gamble by not defending USAG. The court concluded USAG's practices were nevertheless sufficient to support the presumption's application, as invoices were reviewed at 3 different levels, which included review by the chief financial officer responsible for overseeing and authorizing payment of USAG's expenses. As a fact-specific ruling concerning attorney's fees, that determination is due significant deference that the Seventh Circuit, of course, provided and concluded that there is not an adequate basis to disturb it. There is no dispute that USAG was bankrupt and lacked money to spare. Liberty had not identified evidence to challenge the factual finding that USAG used grant money to stay afloat by paying some bills that it incurred. The record does not support, much less require, any finding that USAG stockpiled vast sums of money for legal expenses, which would have removed any need to economize. Because the total value approach for which Shune advocated applies here, in this case, it was unnecessary to scrutinize individual line items in the manner Liberty requested. Therefore, the judgment was affirmed. In my opinion, insurers that take the risk of paying more for the defense of an insured when it refuses to defend and is later found to have erred, and a court orders the insured to defend or indemnify the insured. In such a situation, a presumption exists that the insured, using its own money to pay counsel, paid only reasonable and necessary fees. As the Seventh Circuit concluded in bankruptcy, USAG did not have money sufficient to pay excessive fees, and it was presumed that what they paid and what they were unable to pay were reasonable and necessary, and Liberty must therefore reimburse USAG for those fees. If Liberty had defended under a reservation of rights, it could have controlled the fees, and if it was found to have no coverage, it could seek reimbursement from the insured from whatever assets available from the bankruptcy court or from any other sources that USAG might have had. Liberty gambled it was right and lost, and must pay the fees charged by USAG. This video was adapted from my blog, Zelma on Insurance, which is available at zelma.com and at claimschool.com. Is a video on Rumble and on YouTube. I would appreciate it if you subscribe either to the blog or the videos or both. Thank you for your attention.